Federation versus Freedom by Baba Sahib Ambedkar. 3. C. The Federal Judiciary. The Government of India Act provides for the constitution of a federal court as part of the federal constitution. The federal court is to consist of a chief justice and such puissant judges as His Majesty thinks necessary, their number not to exceed 6 until an address is presented by the legislature asking for an increase. The federal judiciary has original as well as appellate jurisdiction. Section 204, which speaks of the original jurisdiction of the federal court, prescribes that court shall have exclusive original jurisdiction in any dispute between the federation, the provinces, and the federated states, which involve any question of law or fact on which the existence or extent of a legal right depends. This section, however, provides that if a state is party, then the dispute must concern the interpretation of the act or an order in council thereunder, or the extent of the legislature or executive authority vested in the federation by the instrument of accession, or arise under an agreement under Part 6 of the Act for the administration of federal law in the states, or otherwise concern some matter in which the federal legislature has power to legislate for the states, or arise under an agreement made after federation with the approval of the representative of the crown between the states and the federation or province, and includes provision for such jurisdiction. Even this limited jurisdiction of the federal court over the states is further limited by the proviso that no dispute is justifiable if it arises under an agreement expressly excluding such jurisdiction. The appellate jurisdiction of the federal court is regulated by Section 204 and Section 207. Section 204 says that an appeal shall lie to the federal court from any judgment, decree, or final order of a high court in British India if the high court certified that the case involves a substantial question of law as to the interpretation of this act or an order in council made thereunder. Section 207 relates to appeal from decision of courts of the federated states. It says that an appeal shall be to the federal court from a court in a federated state on the ground that a question of law has been wrongly decided, being a question which concerns the interpretation of this act or of any order in council made thereunder, or the extent of the legislative or executive authority vested in the federation by virtue of the instrument of accession of that state, or arises under an agreement made under Part 6 of this Act in relation to the administration in that state of a law of the federal legislature. But subsection 2 to section 207 provides that an appeal under this section shall be by way of a special case to be stated for the opinion of the federal court by a high court, and the federal court may require a case to be so stated. Two further points with regard to the federal judiciary may be noted. The first is the power of the federal court to execute its own orders. The federal court has no machinery of its own to enforce its orders. Section 210 provides that orders of the federal court shall be enforceable by all courts and authorities in every part of British India or of any federated state, as if they were orders duly made by the highest court exercising civil or criminal jurisdiction, as the case may be in that part. The instrumentality, therefore, which consists of which the federal court can use for the enforcement of its own order, consists of the administrative machinery of the units of the federation. The units of the federation are bound to act in aid of the federal court. This is different to what prevails, for instance, in the United States of America, where the Supreme Court has its own machinery for enforcing its own orders. The second point to note with regard to the federal court is the question of the powers of the executive to remove the judges and the power of the legislature to discuss their conduct. In this respect also, the federal court stands on a different footing from the federal courts in other federations. The Constitution does not give the Governor General the power to suspend a judge of the federal court. It forbids any discussion of a judge's judicial conduct by the legislature. This, no doubt, gives the judge of the federal court the greatest fixity of tenure and immunity from interference by the executive or by the legislature. To remove the judiciary from the control of the executive, it has been found necessary that the tenure of a judge must not be subject to the pleasure of the executive. All constitutions, therefore, provide that the tenure of a judge shall be during good behavior, and that a judge shall be removable only if address is presented by the legislature, providing and pronouncing that he is not of good behavior. Some such authority must be vested in somebody which should have the power to pronounce upon the good behavior of a judge. This provision is absent in the federal constitution, so that a judge of the federal court, once appointed, is irremovable from his place till retirement, no matter what his conduct during that period may be. Instead of this power is given to His Majesty under Section 202b to remove a judge of the federal court on the ground of misbehavior or infirmity of body or mind, if the Judicial Committee of the Privy Council reports that he may be removed on any such ground. The end.